Madam Speaker, I yield 2 minutes to the gentlelady from Florida, Ms. Lee.
Madam Speaker, I rise today in support of the resolution to impeach Secretary Alejandro Mayorkas. We are here today to address one of the most serious responsibilities that we can undertake as Congress, the impeachment of Secretary Alejandro Mayorkas. The Committee on Homeland Security has worked diligently to investigate and to consider the causes and the consequences of the catastrophe at our southern border, and it has concluded that it is necessary and appropriate to pursue this impeachment. Since President Biden and Secretary Mayorkas took office, there have been over 8.3 illegal crossings nationwide. We have seen the devastating effects of human trafficking, of fentanyl trafficking, and what happens when we cede operational control of our southern border to the Mexican drug cartel. Secretary Mayorkas has refused to enforce the duly enacted laws passed by this Congress. By doing so, he has endangered our homeland, a direct violation of his oath of office. Even in the face of irrefutable evidence to the contrary, he has given false testimony to Congress, claiming that the border is secure. And he has defied court orders ordering the Secretary to abandon the illegal programs and policies that it has implemented which incentivize illegal immigration. House Republicans know that border security is national security, and the crisis at our border is a critical threat to national security and the safety of the American people. Secretary Mayorkas has willfully and deliberately refused to uphold the laws of the United States. He has violated his oath of office, and he has breached the public trust. Congress has a constitutional duty to secure our border and to ensure our communities are safe. We cannot allow an executive branch agency head to defy the lawful authority of Congress and of the courts in pursuit of policies that are contrary to law and endangering Americans. And that is why Secretary Mayorkas must be impeached. Thank you, and I yield back.
Gentleman reserved.
The lady from Florida is recognized.
Thank you, Mr. Chairman. As we've sat here today, we've listened to our colleagues on the other side of the aisle have a lot of descriptions for this hearing. It has been referred to today as a sham, as a waste of time, as a political stunt. The motives of the members of this committee and the purpose for this hearing have been impugned over and over again, and it could not be further from the truth. First, let's begin by reviewing the reality of the report of Special Counsel Hur, and it was not an exoneration of President Biden. It certainly was not an acquittal of President Biden in any sense of the word. In fact, it was the opposite. That report presented evidence, presented conclusions that not only did President Biden possess classified documents that he was not lawfully entitled to have, that he handled them carelessly, that he shared them with others who were not entitled to understand or see or be aware of the contents of those documents. It did not conclude that President Biden acted properly. In fact, it concluded the opposite, that President Biden acted in a way over and over and over again that is contrary to our law, reckless, and contrary to the interest of our national security. What did the special counsel conclude instead? That President Biden might not be convicted by a jury because he would be perceived as a well-meaning, confused, elderly man. That is the conclusion of Special Counsel Hur. Not that there wasn't wrongdoing, but that a jury might be so taken by the confusion of a well-meaning elderly man that it would choose not to convict. And so what brings us here? The good faith efforts of this committee to identify the truth and the facts of what went on in those interviews with those documents, who saw them, what does this mean for our country? What risk has been posed to us because a president of the United States chose not to handle these documents correctly? There is a not only valid, a vital purpose to this hearing today. Moreover, when we serve a subpoena, we're just looking for compliance. And all of this about this witness and an opportunity, he's had opportunity after opportunity after opportunity to comply. And so now we have a report in front of us that recommends a finding of contempt, and as we should. Not only should we find him in contempt, that we should be unanimous about the fact that there has been a lack of compliance and contempt in this circumstance is warranted. And with that, Mr. Chairman, I yield to the gentleman from North Carolina.
He yields back. Chair recognizes now the gentlelady from Florida, Ms. Lee.
Mr. Tolman, I'd like to go back to a concept that you raised earlier that I think is one of the really broad ideas we need to focus on here today, and that is that the advent of over-criminalization empowers rogue or politically motivated prosecutors to identify a person or target to prosecute rather than bringing criminal prosecutions based upon community needs, community safety, or the principles necessarily of fairness and equity. And you raised a particular example that I believe is instructive, and that is DA Alvin Bragg. I'd like to return to him for just a moment. Mr. Tolman, it is correct, is it not, that the case that Mr. Bragg brought against President Trump is actually predicated upon a set of misdemeanors for which the statute of limitation has run?
Yes, that is correct.
And would you agree, Mr. Tolman, that in fact that case is a good example of over-criminalization leading to selective or what appears to be entirely politically motivated prosecution?
When they have so many tools at their disposal and the ability to manipulate them, that is what over-criminalization ultimately leads to, is the use of the criminal code for something other than administration of fairness and justice.
Mr. Patil, I'd like to return to testimony that you gave in your opening statement that referred to criminal conduct that was not inherently blameworthy, rather the criminalization of conduct that wouldn't inherently be identified as wrong or blameworthy. And I'd like to discuss the concept of mens rea. How do you think we could use or integrate the concept of mens rea to ensure that that type of conduct to which you refer is not criminalized?
Well, I thank you for the question. The concept of mens rea is critical. I think it was Oliver Wendell Holmes who said, even a dog knows the difference between being tripped over and being kicked. That guilty mind element is a necessary component to take away life or liberty from someone. So I think one of the things that can be done is really taking a look where this shows up more often than not is in the regulatory realm, where either Congress has given vague or an ambiguous term to an agency and the ability to criminalize behavior, or an agency is stretching beyond a little bit, maybe a little beyond what Congress had intended it to be able to do. But I think that there was a bill a number of years ago that would have simply, if there was no mens rea in a federal statute or a federal regulation, it would insert a default mens rea requirement into the regulation or the statute. And I think that that would be a huge step forward by Congress.
And Mr. McLaughlin, or Dr. McLaughlin, I'd like to go back to testimony you gave earlier as well. You used as an analogy the base realignment and closure commissions as a concept on how we might come at identifying all of these regulations and all of these things that we need to take account of and address as Congress. Would you go into some more detail there about your thoughts on how we might identify all of these regulatory agencies who have acted with such overreach and diminish the amount of these purported crimes that are out there?
Sure. The Bragg Commissions was an example of, they put together a blue ribbon panel of experts to look at what can we get rid of, where we need to keep, what's essential. That's just one approach. I think another approach that we've seen be very effective in finding someone to go back and identify regulations that could be cut because they aren't accomplishing their purpose but they're creating harm is regulatory budgeting. And this is where you put the agencies themselves on the task of finding old regulations that they've written and that they can get rid of. And you say, if you want to make a new regulation, great, go do your job. But if you're going to do that, get rid of something that's on the books and has been there for 30 years that you think isn't effective anymore.
And then you mentioned also that you particularly utilized data and research and analysis in your work in identifying where these problems might exist. Are there ways in which you think Congress could use the same types of tools to assist us in our work?
Sure. One easy example here is the dates when statutes and regulations were made and looking if they've been updated, especially regulations. I can run a computer program through this Code of Federal Regulations and find when each regulation was last updated. If something hasn't been updated in 20, 30, 40 years, maybe it's time to get rid of it, or at least look at whether it's time to get rid of it.
Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. Chair now recognizes the distinguished ranking member from Texas, Ms. Jackson Lee, for her.
Secretary of State of the state of Florida for 5 minutes for asking her questions.
Thank you, Mr. Chairman, for convening this important hearing, and to all of our witnesses who are here today. It is indeed a pleasure to see you. As Florida's former Secretary of State, I appreciate how important your jobs are and how critical your jobs are to American confidence in elections and ensuring that we have free and fair elections in the United States. So thank you to all of you for being here today. Secretary Byrd, I'd like to go back to you. You mentioned in your opening a couple of concepts that I think are very important as it relates to public confidence and really an example of some of the best practices that we could see in elections in our country. I'd like to start with voting systems and transparency. Is it correct, Secretary Byrd, that the Florida Department of State tests and certifies every voting system before it is used in an election?
That is correct.
Is it also true, Secretary Byrd, that before an election, local election officials perform testing and auditing of those systems again before they are used?
Yes.
And that testing and auditing of the election systems prior to every election is open to the public, is it not?
Absolutely open to the public.
And would you tell us this, while voting is going on during elections, are those voting systems ever connected to the internet?
They are not connected to the internet.
In other words, Secretary Byrd, is it possible to hack a voting system during an election?
It is not.
Would you tell us, Secretary, why it is you think that these measures you've just described are important and how they relate to public confidence in elections?
Well, everything we do in Florida is to build voter confidence. And while we have 67 counties and 67 supervisors of elections who are independently elected constitutional officers, we have a uniform election code, and it's my job and your former job as the chief elections officer of the state to make sure that we accommodate the needs of our largest county in Miami-Dade and our smallest county in Liberty County, that they can all operate with different resources and funding at the county level, but they also follow the state law.
I'd like to go back to something else that was mentioned earlier in this hearing. There was reference made to what was described as Governor DeSantis's election police. In fact, Secretary Byrd, is that not the Florida Department of State's Office of Election Crimes and Security?
It is. It was one of the governor's top election integrity priorities to create the Office of Election Crimes and Security. That office, which is housed in the Department of State, we investigate allegations of election fraud and crimes. And I think it's really important to note that people think, when they think election fraud, they think of the presidential race. Election fraud includes campaign finance violations, voter registration fraud, initiative petition fraud, candidate qualifying fraud. We investigate all of those. And for all of the people who say there is no evidence of non-citizens voting and all of the, come to Florida. We have the evidence because I'm required, my office is required to report it to the governor and the legislature every year.
And if you would, touch on the petition gatherers, what that is, and explain for us why that is harmful to both the public and the elections process if there is fraud occurring during the petition gathering process.
Those initiative petitions change or have the potential to change our state constitution. They enshrine, if they pass, they enshrine it in state law. There are organizations and businesses that send people from out of state into the states, pay them to gather signatures. We have victims of felony identity theft. They have come and reported that to us, that their signature has been put, that their identity has been stolen, their signature has been placed on a signature petition. We have a duty and obligation to investigate and provide relief to those victims, but also most of the reports of election fraud in Florida are reported by the county elections officials. It is happening, and it is our duty under the law to investigate.
And then one of the things, this question I'll direct to all of our secretaries who are here with us today. One of the things that we've heard discussed during this hearing is the Election Observer Program, which Congress administers across the country, and this committee runs that program, and we deploy trained congressional staff and send them around as those observers in elections offices around America. And I would like to hear from each of you on really just a yes or no, if your office is prepared and ready to welcome these election observers during this election cycle. We'll start with you, Secretary Byrd.
Yes, we welcome them.
Proudly.
Yes.
Of course.
Yes.
Happy to have them.
Right. Thank you all, and with that, Mr. Chairman, I yield back.
From law enforcement and the court system as it's existed for. With that, I yield it.
Would the gentleman yield?
The question.
I would suggest as follows. There was a time and a place to have this conversation, and it was prior to the date and time that Mr. Biden was ordered to appear for testimony. And that conversation should have occurred between Mr. Biden's attorneys and this committee. It did not. And at this point, he was lawfully ordered to appear for testimony, failed to do so, and I, along with many of the others in this room, have practiced law, been in court, served as a judge, and if we do not enforce our authority to compel testimony, it is not worth the paper that it's written on. Today, we have a witness who has failed to appear. Our authority to compel testimony, it is not worth the paper that it's written on. Today, we have a witness who has failed to appear, who has flouted the authority of this committee, and indeed had the temerity to conduct a press conference rather than appearing pursuant to that requirement. The only appropriate action for us to take today is to proceed with an ultimate finding of contempt. Any subsequent conversation that we want to have about terms of testimony, how it should be conducted, when, where, all of that can be continued, discussed after we make the appropriate finding of contempt at today's hearing. With that, I yield back.
Would the gentleman yield?
Yield back to the gentleman from North Dakota.
The gentleman yield. Mr. Chairman, I would ask in a colloquy for
5 minutes. For months now, we have been hearing these staggering statistics about the catastrophe at our southern border, the millions of migrants coming across our border illegally, the human trafficking, the fentanyl, the lost unaccompanied minors. But today we hear something that is even more important than that. Today we hear the real personal stories of unfathomable loss and irreplaceable lives. And yet, even in the face of this testimony that we have heard today and the testimony that came before it, our colleagues across the aisle impugn the purpose and the necessity of this hearing, calling it a political sham, calling it a stunt, calling it theater. And they suggest that what we actually need to do is pass more laws. So as a former federal prosecutor and judge, I'll start today with a refresher on a few of the things that are currently illegal in the United States of America. It is illegal to traffic fentanyl in the United States of America. Human trafficking is illegal in this country. Theft is illegal in this country. Rape and murder are illegal in this country. What's more, the Department of Homeland Security has an absolute obligation to detain and remove those who enter this country illegally. We do not need more laws. We need a President of the United States and a Secretary of the Department of Homeland Security who enforce the laws of this country. But what do we have instead? An administration that has deliberately subverted the duly enacted laws of the United States of America, that have deliberately defied the orders of courts in this United States of America, who have ordered and directed that they desist these unlawful policies. We have a Department of Homeland Security that has defied inquiries from the United States Congress. And as for the 27 appearances of Secretary Alejandro Mayorkas in front of this Congress, not one of those times did he admit that we have lost operational control of our border, that we have ceded control of our border to the Mexican drug cartels, or acknowledge the scope, scale, and crisis that our communities all across America face as a consequence, as a direct consequence of these lawless policies. Every single time an individual is allowed to enter this country unlawfully, Americans are less safe. Ms. Nobles, Mrs. Dunn, as a mother, I see my child and my family in those photos that you shared with us today. And it is truly something that we cannot fathom, the loss that you have each suffered. I thank you for your willingness to come here today and share with us your stories. I would like to hear your perspective, please, on what more Congress could be doing to support you and to try to prevent this type of unspeakable tragedy from happening in the lives of another family? We'll start with you, Ms. Nobles.
I would like to see every illegal immigrant who wants to come here to be properly vetted and background checked. I hear a lot about more funding, resources, and all that. How is that going to help them do their job in the first place? They failed Kayla by not checking her murderer's background and did not make that one phone call. One phone call could have saved my baby's life. They didn't. And after he was arrested, Child Protective Services took him and put him in an unsecured children's home with other children. And I know Americans commit crimes on other Americans, but why do we have to take other countries' trash? Why do we need them?
Ms. Dunn?
We talked about a lot today about more resources at the border. And I appreciate that, and I respect that. But I don't think that members in this room and other rooms at the Capitol understand that we are actually at war. And we're at war with the cartels. We're losing our children. We're losing a generation of children. We're at war. We need our military at the border. That's what we need. We don't need more Border Patrol. We need our military at the border, stopping the drugs, stopping people from coming in. They can't come in. We're full. We're closed. That's it. No more money. No more. No more sandwiches. It's closed. I'm sorry. Come through the proper channels. I am a first-generation American. My parents both migrated here. Guess what? They did it legally.
Thank you, Mrs. Dunn. My time has expired. I now recognize the gentleman.
Gentlelady yields back. Does Mr. Ivey have
We're out on this side, but I would offer
unanimous consent?
unanimous consent for two letters that may address Ms. Hageman's line of questioning. One is dated April 22nd, 2024 from the Department of Treasury, and it's addressed to you, Mr. Chairman. It's from Corey Tellez, who is the acting secretary, and the other is, she may have referenced, I'm not sure, from the Department of Justice to you, Mr. Chairman. It's from Mr. Uriarte. It's dated May 31st, 2024.
And I would ask for unanimous consent for an article, Cartels Infiltrating Native Reservations with Fentanyl, according to a tribal leader.
Thank you. Without objection. Gentlelady yields back. Gentlelady from Florida is recognized.
Good afternoon, Mr. Attorney General. This committee is well aware of your long tenure as an appellate judge on the D.C. Circuit and your time as an AUSA before that. And I am sure that you, like me, care deeply about the public confidence in our court system and specifically our judiciary. And you said something a few moments ago that I think is a very important principle. You said that judges put aside their personal views and their political views when they preside. And I agree that that is the expectation. Not that judges don't have personal or political views, but that judges set those beliefs aside when they consider and rule upon cases, and that they do so in a way that is impartial and consistent with the law. And so I'd like to discuss the recent increase in aspersions being cast at some of our Supreme Court justices, some of which we've heard repeated during this hearing. Public calls for recusal of justices based on conjecture and conspiracy about their political beliefs, and in fact, not even the supposed political beliefs of the justices themselves, but even more attenuated to the supposed political and personal beliefs of their wives. In your view, Mr. Attorney General, is it appropriate to attack the impartiality and integrity of the Supreme Court justices in this way?
So I'm going to have to say again what I said before, which is we have cases before the Supreme Court, so I'm not going to be able to comment on this. You haven't heard any aspersions cast by me, and you won't hear any, but all of our filings will be done in court, and I'll only speak about these matters in court.
So then let's discuss this not as it relates to the specific justices who have had their integrity attacked today, but more generally in the case of judges who are presiding. Now, in general, in your experience on the bench, did judges in the D.C. Circuit recuse themselves if they believed they had a conflict of interest?
Yes.
And in your experience, did they typically adhere to a very high standard of personal integrity?
Yes.
And do you have any reason to believe or any personal belief that the justices of the Supreme Court currently have any issues that would necessitate their recusal?
So you've now skipped over to the question, which I said I wouldn't be able to answer. I can't comment about the Supreme Court. We have cases in the Supreme Court right now, and all the time.
So let's talk about the matter of judicial security. So not long ago, we had Director Wray of the FBI appear before this committee, and I questioned him about the lack of FBI resources and focus being allocated to threats against the safety of judges and specifically Supreme Court justices in light of some of the alarming news in recent times. And one of the things that he pointed out, in fairness, was that the U.S. Marshals take a large role when it comes to the security of judges. But in your role, you have the unique opportunity to actually oversee both branches there. So I'd like to know more about what the department is doing related to threats against judges.
Okay, fair enough. So this is one I can talk about. With respect to the justices themselves, for the first time in history, an attorney general, namely myself, ordered that every justice get 24/7 protection for himself or herself and their families at their residence and on their travel. So I've assigned over 70 U.S. Marshals who are doing this daily, but because of rotations, it's involved almost 1,700 Marshals across the country to provide immediate protection. Now, the FBI, both the Marshals and the FBI investigate threats against a justice. This is in our highest priority band protection against the judges, protection against threats against justices and judges. And I'll be happy to provide you with the press releases of our charges. There have been threats against several of the justices, and we have brought cases against those who have threatened them. We have a lot of judges in the country, and we don't have enough marshals. So I'm sorry to say the same thing I said before, which is we need more money for the marshals for protection, because not only do they protect the justices, they have to protect the judges in courthouses in 94 districts in the United States.
Thank you, Mr. Chairman. I yield the balance of my time.
Gentlelady yields back.
Mr. Speaker, this bill should not be controversial. The vast majority of Americans agree that only U.S. citizens should be voting in our elections. The Safeguard American Voter Eligibility, or SAVE Act, is a crucial piece of legislation that will protect our elections and ensure American citizens have confidence in our election system and that their vote is not being canceled out by those who are not legally eligible to vote. As Florida's former Secretary of State, I oversaw all of Florida's elections, working diligently to ensure that Floridians had accurate and fair elections that they could be confident in. Now, as the House Administration Subcommittee on Elections Chair, I am working to advance policies that lead to stronger elections across our nation, like the SAVE Act. While it is already illegal for non-citizens to vote, this legislation provides much-needed enforcement and tools for states to verify that their voter rolls are accurate and that illegal aliens are not slipping through the cracks and voting. We all know that President Biden's border crisis poses a clear threat to our election system, as millions of illegal aliens have poured into our country at record levels. In recent years, election outcomes have included razor-thin margins. We must ensure that Americans can trust our elections administration process. And one of the sure ways to accomplish that is by ensuring that non-citizens do not vote in our federal elections. Recently, we have seen documented instances of non-citizen voting in jurisdictions across the country, including right here in our nation's capital. That is unacceptable. The SAVE Act will strengthen current law by requiring documentary proof of U.S. citizenship to register to vote in federal elections. As a former elections official myself, I urge my colleagues to support the SAVE Act to enhance election security, to minimize the risk of foreign interference, and restore Americans' confidence in U.S. elections. Thank you, and I yield back.
Discuss the ANS.
Thank you, Mr. Chairman. And on that note, here we are again, subjected to the characterizations of House Democrats who attack the purpose and the validity of this hearing, who have today referred to it as a waste of time, a sham, a joke, a political game, a policy dispute, and even said that no serious member would pursue these articles of impeachment. In fact, Mr. Chairman, the opposite is true. No serious member could sit in this room and look at the American people and deny the catastrophe at our southern border. No serious member could deny that it is past time for accountability. No serious member could look at the American people and say that lawlessness is acceptable, that it is acceptable for one branch of government to defy the others willfully, purposefully, and with impunity. And that is precisely what Alejandro Mayorkas has been doing all of this time. Mr. Mayorkas has indeed defied, first, the courts of the United States of America. Of course, these matters have been litigated. Of course, the states are fighting for safety of their citizens, for the security of our borders. And what has he been told? Courts have ruled that his subversion of the parole process, his use of that as a way to get around the laws of the United States is unlawful. He's been ordered to desist. He did not. He's been ordered to reinstate remain in Mexico. He did not. He's come to this Congress and he's given testimony before us that was demonstrably false, stating that our border was secure, stating that he had operational control of the border, when in fact, every person in this room, and I dare say the vast majority of America, knows that is not the truth. He has misled this committee. He has misled the American people. This process, this committee's process in consideration of this day has been methodical. It has been serious. It has been thoughtful. We have heard from the men and women of local law enforcement. We have heard the catastrophic and tragic effects to their communities that this failure to enforce our laws has caused. We heard from families who have lost their children, deaths from fentanyl poisoning. We've heard the tragic stories of human trafficking, not only of Americans, but of those who are crossing this border illegally that are being exploited. We have heard these stories week after week. And rather than call them a waste of time, as our Democrat colleagues have done, we need to hear them, we need to heed them, and we need to take action. Because here is the reality. Every single day that Secretary Mayorkas continues in his role, America is less safe. We have ceded control of our border to the Mexican drug cartel, and we have seen the tragic and irrecoverable consequences of doing so. Not only are these articles of impeachment appropriate and based in law, it is our duty to ensure that the United States of America is a nation of law. It is our duty to ensure that our border is secure. And it is our duty to ensure that Secretary Mayorkas faces the consequences of his actions and the consequences of deliberately and willfully creating this catastrophe. Mr. Chairman, with that, I yield back.
The gentlelady yields. I now recognize Ms. Ramirez for 5 minutes. I now recognize the gentlelady, Ms. Lee from Florida, for 5 minutes of questioning.
Secretary Mayorkas, I'd like to continue the discussion about the Cybersecurity and Infrastructure Security Agency, and specifically the Chemical Facilities Anti-Terrorism Standards Program that is overseen by CISA. The CFATS program, would you please describe for us how your budget provides continued support for the CFATS program?
Congresswoman, I'll have to remind myself of the specific funding for that program. That funding is very important, and of course it has been in tremendous peril recently. We strongly support the continuation of the CFATS program. It enables us to ensure that high-risk chemical facilities are as secure as they need to be.
And would you agree that a continuation of that program is an important part of the mission to protect critical infrastructure?
I would, Congresswoman.
And would you also encourage our friends and partners over in the Senate to take up the bill that was passed by the House and is currently there awaiting their consideration and action?
Congresswoman, I'll look forward to reviewing that bill again, but we do indeed consider the CFATS program to be very important.
And I'd like to then return to the subject of CISA and its role in elections infrastructure and its efforts to help state and local election officials protect elections infrastructure. Specifically there, could you describe what CISA does to help state and local elections officials defend against threats from foreign adversaries and domestic adversaries to that infrastructure?
Congresswoman, one of the things we do is provide training with respect to the threat, to be able to identify the threat. We share best practices. We have marked election security as one of the 6 priority areas in some of our Homeland Security grant programs to ensure that state and local jurisdictions devote needed resources to a fundamental need of our country, and that is to safeguard the integrity of our election processes.
And moving to the question of breaches and cyber attacks, what efforts is CISA making to bolster its own internal cybersecurity? I know they were victim to a recent cyber attack. Can you describe for us the efforts internal to CISA on cybersecurity?
Congresswoman, so that is a priority for the department as a whole. Our Chief Information Officer and that team is consistently working day in and day out to enhance our security. In addition, CISA works to enhance the cybersecurity of the federal civilian domain. It issues binding operational directives based on what it learns from particular incidents to ensure that agencies and departments are patching or protecting themselves against detected vulnerabilities. This is a very significant mission area of ours. The cybersecurity threat vector is not, unfortunately, diminishing.
Related to HSI, I'd like to go back to that subject, which you addressed earlier as it related to some transnational gang activities. But specifically within your budget, I'd like to discuss HSI and its operations related to child exploitation and human trafficking. Your budget calls for additional funding there to help HSI investigators combat human trafficking, does it not?
Yes, it does.
And would you explain for us the types of activities and role that HSI takes specifically as it relates to the exploitation and trafficking of children?
Congresswoman, I named crimes of exploitation one of our 6 mission priorities for the first time in the department's history. Tomorrow I will be with HSI, Homeland Security Investigations, in New York City, launching a new campaign against online child sexual exploitation and abuse. This is a scourge that is not only nationwide, but is global in nature. More than 36 million tips were presented to enforcement authorities across the world. Domestically, more than 63,000 of them reflected an imminent or grave threat. The extent of this crime cannot be overstated. The work of HSI in combating it is heroic, both in disseminating education and awareness, in investigating the crimes, in rescuing victims, and holding perpetrators accountable.
Thank you, Mr. Chairman. I yield back.
The gentlelady yields.
At this time, I recognize Ms. Lee for 5 minutes.
Thank you, Chairwoman Bice and Ranking Member Kilmer, for holding this important hearing, and thank you to all of our witnesses for appearing today. Ensuring the continuity of Congress in a time of crisis is a sobering but critical task for us. In contrast to the Senate, as we've discussed today, the Constitution requires the House vacancies to be filled through special elections, thereby ensuring that the people decide who their elected representatives are. As chair of the Subcommittee on Elections, I am interested in ensuring that states are equipped and prepared to smoothly and expeditiously fill House vacancies through special elections in the event of the unthinkable. Ms. Gambler, I would like to return to your testimony. Thank you for the preliminary insights that you have shared with us from the GAO's ongoing review of state capabilities for holding special elections for House vacancies. I'd like to go back to the input that you got from the survey from state elections officials. 9 states have passed laws concerning special elections that mirror the federal 49-day requirement, but it sounds like some of the states have been more successful there than others. Would you elaborate a little bit more on the types of procedures that the 9 states who do mirror federal law have adopted? What aspects of those laws have they been able to successfully implement?
Absolutely, Congresswoman. Thank you for the question. So there's a little bit of variation across those 9 states, but generally most of them have adopted into their state laws provisions addressing the 49-day time frame that's specified into USC 8B. A few of the states have also addressed other aspects of 2 USC 8B, which is the federal law we're talking about, and those include provisions related to the candidate selection process and the transmission of ballots for military and overseas voters.
So if you would, share with us the candidate selection process and how they've modified qualifying. You touched in your statement earlier on using political parties to help identify who the candidates are going to be. Elaborate for us on how that candidate qualifying process has been adjusted in these 9 states so that they can meet the 49-day timeline.
Yes, thank you for the question. We haven't looked in detail at what the specific procedures would be for candidate selection in those 9 states in particular. But what I can say is that for some of those 9 states, they have particularly adopted the timeframes that are specified in the federal law that we're discussing related to identifying candidates. So it's really the time frame piece that we're speaking about.
And the other thing that you brought up specifically is the UOCAVA, our overseas voters, our overseas military voters. There are also provisions in federal law that tell elections officials when those ballots need to be mailed, how long they need to be out there. Did you discover that some of those provisions are inconsistent with a requirement that we fill these seats in 49 days?
Yes, thank you. I think that's an important point. So there are differences in the timeframes for the transmission of ballots to military and overseas voters between what's specified in 2 USC 8B and what's in UOCAVA. 2 USC 8B specifies that states are to transmit to the greatest extent practicable ballots to military and overseas citizens voters within 15 days of Speaker's announcements. In comparison, in UOCAVA, the requirement is to transmit those absentee ballots within 45 days of Election Day. So there is a difference there between those 2 federal requirements, and we did hear from the state election officials that responded to our survey that could be a point of challenge for them in holding a special election.
You also mentioned some of the procurement and logistics issues that were raised in these surveys related to ballot preparation, ballot printing. Can you share with us a little bit more about the other logistical challenges that were identified for you?
Absolutely. So there is, of course, a relationship between candidate selection and ballot preparation. We heard in doing our work that the selection of candidates is obviously important so that ballots can then be printed and prepared. And we did hear from states that it could be challenging to prepare and print ballots on a compressed time frame because of what their existing state laws and procedures are related to ballot preparation, but then also issues related to things like the availability of ballot paper stock, which is used for ballots. So that was an area of concern identified as well.
Thank you. Madam Chairman, I yield back.